Hi, my name is Ryan Hopkins, and I am a construction partner at White & Case in Houston, Texas. If you watched part 1 of this series, Project Communications, or part 2 of this series, Construction Contract Management, then you already know that I believe a key part of managing construction contracts is good, clear communications and knowing your contract. If you teach your project team to communicate professionally and clearly, and to use the contract to manage the project effectively, it will reduce their workload and issues on the project. But nothing will completely eliminate issues on large construction projects, and nothing will prevent every dispute. Which brings us to part 3 of this series, Defending Your Contract. Before we dig in, let's set the frame of reference. As I suspect you know if you've worked on construction projects in the US very long, we live in a litigious society that contains a relatively unique judicial construct. The fact that it only takes a short and plain statement of any claim to file a lawsuit, known as notice pleadings, is shocking to much of the world. And then the fact that parties can use discovery to access anything relevant to the claims, including the opponent's case, is likewise shocking. But these basic steps are key to encouraging the majority of cases in the US to settle. You see, if the facts are clear or the law is decisive on a particular issue, then the parties are likely to resolve it themselves. Add to that the significant cost of conducting litigation discovery, and the parties are highly encouraged to reach a resolution, which brings me to why this is important. Generally, other than a very small subset of exceptions such as ego or public relations and the like, issues only make it to litigation when the facts or law are ambiguous. As most of you know, if you have dealt with a complex construction project that was late, there is nothing more ambiguous than a delay analysis. If you find yourself in a construction project that has accumulating issues, then I hope that you've trained your team to communicate clearly and professionally and employ the contractual levers available to influence the project execution. But if the issues begin to build towards claims, then you need to use your communications to develop your story and defend your contract. As I discussed briefly in part 2 of this series, I am seeing the market shift away from the zero-sum game that has pervaded for quite a while in construction contracts. Clients and contractors are searching for ways to work more collaboratively to resolve issues that arise. I firmly believe that it is best for the industry and best for the lenders and investors as well. That's what led me to developing parts of my courses several years ago. Teaching project teams to know the contract, identify the issues earlier, and use the tools available to resolve those issues leads to a better project outcome for everyone. But sometimes, circumstances, an oversight, or a contract ambiguity result in an unavoidable dispute. It's then that a well-drafted dispute resolution procedure can create options that may elevate the dispute above the project team so the work can continue, resolve the dispute through an abbreviated method, or result in arbitration or litigation. Now, the one thing I would caution about is a one-size-fits-all approach to dispute resolution procedures. Both parties need to really buy into a proposed method that elevates or abbreviates dispute resolution. Otherwise, it just further delays the inevitable to the detriment of the project. So what should your project team do when you encounter one of those difficult issues and despite your best efforts a claim is building? You need to perform a contract analysis to understand the options and limitations that both you and your contractor have in influencing and resolving the issue. As I discussed in part 2 of the series, there are often many levers to try and influence the outcome, but some of them, such as set-off rights, securities, and descoping, can also be used to defend your contract. However, the key after analyzing the contract and the facts is ultimately to know your story. It is important to recognize the difference between negotiating an issue and an arbitration or litigation. When you are negotiating an issue, the parties will endeavor to find and use the facts to resolve issues. If the facts are ambiguous, the dispute will likely continue. Sometimes the parties will analyze their individual risk in an ambiguity and find a settlement, but often human nature takes over and the dispute will escalate. As I said, if there were clear facts to win, you probably would not be in litigation. In litigation, it is often the better story that wins. Sometimes the better story is built purely on facts, but often the better story is told by the better storyteller. Therefore, one of the keys to building your defense, or claim as the case may be, is to decide early on what options you have for a story. Unless you are forced, I recommend keeping several story options open to provide your litigator options. You can do this by developing your facts as thoroughly and as early as you can. If you have managed your project communications effectively, then it should be relatively easy to create a timeline of events around which to develop your facts. Of course, this is a good time to remind you of attorney-client privilege and attorney work product privilege. In case you have forgotten, attorney-client privilege protects communications between an attorney and client regarding legal advice. Attorney work product privilege applies to an attorney's thoughts and strategies regarding a case. By the time that you begin developing your story, you should be working under the direction of an attorney, either an in-house counsel or outside counsel, to protect both your strategies and any new information created to further your story. If you begin creating new documents, including management reports and contract analysis, without the direction of an attorney, then you risk having to produce that information to the other side during discovery. With that in mind, opinions and interpretations should be left to the experts, and an attorney should be guiding the development and dissemination of opinions and interpretations to provide protection from discovery. Specifically, the project team should not be interpreting the contract, making assessments of potential claims, or creating management dispute reports. Facts are facts are facts. There is no need to try and hide facts, nor is there a need to not report those to management. However, everything else about a dispute should be developed and reported through an attorney. Which brings me to messaging. I find that clients naturally begin to develop their facts when a claim arises. And with a little training, most are aware of the issues around developing additional discoverable materials with opinions and interpretations. However, most clients forget to address messaging. All of us have experienced the rumor mill that exists in an office environment, and I often find it is magnified on a project site. So I recommend to executive management and project management teams that they develop a consistent internal messaging regarding issues and disputes for internal communications with employees and project personnel. This will help to control information flow, misinformation, and maintain morale on the project. Similarly, management teams need to develop a consistent external messaging as well. It would be ideal to limit all external communications to a limited set of personnel. But because the project typically must continue, it is impossible to stop interactions with customers, vendors, affiliates, etc. And of course, due to the rumor mill, another benefit of good, consistent internal messaging is that it hopefully helps control the unintentional external messaging. I also find that clients overlook developing a public relations strategy early. However, just like developing your legal storylines, you should prepare public storylines. You have to anticipate that your contractor may decide to use the media or may choose to file the dispute in a public forum that draws the issue into the public realm. Not only can this affect things like your stock price, if you're a public company, or your credit rating, it can also affect other contracts, regulatory bodies, and local relations. Therefore, preparing a public relations strategy, training specific personnel to deal with the media, and issuing internal guidance to the project teams are an important part of any dispute strategy. Once you have developed your options, it is time to execute your defense strategy and further develop your story. As I stated earlier, hopefully at this point you have involved legal counsel early in the process to develop options and a dispute strategy that supports the preferred litigation story. But you also need to continue to involve your attorney to further develop those storylines. Unfortunately, I find resistance to involving attorneys early, often because in-house counsel is either overtasked and external counsel is too expensive. Even if an attorney was involved early, resistance from the project team often persists as the dispute continues to develop because the process is usually just very slow. However, I encourage you to train your project teams to understand that keeping the attorney involved throughout can elevate the dispute away from the project site to continue the work, It can also be a useful scapegoat to preserve working relationships, and it can significantly save costs in the ultimate dispute through better documentation and improved discovery process. To further support executing the dispute strategy and developing the story options, I also recommend that clients appoint a claim manager. This person should be responsible for managing the strategy, particularly by monitoring project communications, maintaining documents and records, and communicating with management and legal representation. This helps limit unnecessary risk created by too many personnel communicating regarding the dispute. Finally, as we used to say in the Army, semper gumby, which means always flexible, or as Mike Tyson famously said, everyone has a plan until they get punched in the mouth. I noted earlier that you want to keep as many story options available as possible. This provides the flexibility to adjust as the dispute develops, and you get a better sense of the contractor's strategy and any surprise facts that arise. So I said in part 2 of this series that I would tell you the result of my example. As you may recall, we ultimately descoped a significant portion of the work when the contractor proved incapable of recovering the schedule or even demonstrating improvement that would warrant not going through the pain of descoping work. Now let's be clear, the facts supporting the contractor's story were valid, and both parties were to blame for some portion of the delay. However, because my client involved legal early, we had developed a clear strategy that fed into our story. As I said, that first notice drew a line in the sand that gave my client the moral high ground because it demonstrated effective contract management and clear communication regarding the developing issue. It was the first piece of evidence referenced by the tribunal to reject a claim that the contract was not being properly followed. The recovery notice was the second piece of evidence demonstrating effective contract management and clear communication between the parties. And it built a timeline of supporting evidence demonstrating the contractor's repeated failures. And when it came to damages, the well-drafted descoping provision protected my client from additional costs to complete the work, and we had ensured that invoices were properly paid and any amounts disputed or set off to mitigate damages was done with proper notices, which limited their counterclaims. Ultimately, the case was a success over a period of 2 years. As I said in part 1 of the series, there is no grand secret to tell. A return to basic communication skills and fundamental contract execution will alleviate a lot of issues on construction projects. When that doesn't work, you can take active steps using the contractual levers to guide the behaviors of the project teams and drive towards dispute resolution while defending your contract. Thank you for joining me on this 3-part series, and I look forward to seeing you next time.